It's fine.
Hello, everyone. It's Irene Kashansky here from the Keller Williams Portfolio Realty Office, and very, very proud and honored today to host Sonia Kossifer. Wonderful, wonderful. Is lawyer okay, or is attorney better?
No, lawyer.
Yeah. Who will be speaking to us about the importance of wills and estates. I know we've got more people jumping on, so we will just get going. And Sonia, maybe I can give you the floor and let you do a bit of an intro and take it over.
Thank you, Irene. I'm Sonia Kossifer. I have been a lawyer for quite a while now. I realized I had to update my bio and realized it was like 20 years. So that's always shocking to see. I have worked in various places, and where I've landed now is with a partnership, TVH Group, and I head the legal department. I do real estate, wills and estates, and business. I do both residential and commercial real estate as well. And I partnered up with three wonderful people who do financial advising, mortgage brokering, and accounting. So we provide a full strategy for our clients who are looking to reach their financial legal goals. I have been doing real estate for quite a while now, but as a result of doing real estate, clients need wills and they need estate planning, and they need to think about that because a lot of the times we put this on the back burner, and we don't really want to have that lingering. So it's really wonderful that I can do this, and you guys that are at the forefront of the real estate can be putting the important idea into your clients' heads that after the real estate transaction is closed, let's get a will in place. And the more that a client can be told, eventually it happens. And it's very important. And I'll explain why. But if everyone can actually take a minute and just introduce themselves as well, I would love to know your names, although I can read them, but also know what you're doing and why this would be helpful to you and your clients.
Awesome. L'Oreal, and do you want to start?
Sure. Hi, I'm L'Oreal Cram. I'm a realtor with Keller Williams Portfolio. I think this would be great for me, not only personally, because we should all have this, and aging parents and all of that as well. Professionally, I want to get my senior specialist designation, and I think that having this information is more helpful than not. So I'm learning for myself and my clients. There's such a pool of people that are downsizing now, and the boomer generation is just huge, and I've worked with a lot of them, and so this I think will just help me be better informed.
That's awesome. Well, Natalie, that's a focus for you as well. So while you're up, Sonia asked if we could just you could do a quick intro and let her know what you hope to achieve from the session.
Hi, I'm Natalie Lewin, and I work with downsizers as well. And so any value add that I can add to them, I want to know so I can make their process more profitable for them and easier.
Great. Lan.
Hi, everyone. Sorry, go ahead.
Yeah, go ahead, Lan.
My name's Lan. I am from iPro, and just from 3 years ago, so I'm quite new in the industry, and I am usually buyer represent. That's why I would like to know about the process with will and estate. I saw a lot of estate sell now, and I would love to know about the processing and what is to affect my client. Thank you.
Great, thanks. Ben.
Sorry if I interrupt you first. My name is Ben Ghashloghi. I'm brand new. I'm working with Keller Williams portfolio. And I think it's very crucial to learn about estate planning and tax planning in today's world, because clients want to keep their wealth, save it for the next generation. And I'm so passionate to learn about that.
Awesome, thanks. Sam?
Oh, sorry, I'm multitasking here.
That's
Hi,
okay.
my name's Sam. I'm on Irene's team and with Keller Williams portfolio. I honestly, I guess this is a selfish reason, but I wanted to know more about it for my family because we do have grandparents who are older and I don't think there's anything in place. Same with my parents, they're getting up in their 70s, but I would love to hear more about how I can open up that conversation appropriately to clients, because I think that would be great.
Nothing selfish about that. You're going to be helping people no matter what. So I think that's great. Thank you.
Get informed.
Yes, for sure.
Robin?
Kind of like Sam, I'm just here to learn more about wills and estate planning. Why not?
I like that.
Short and sweet. All right. Okay, we'll give you the floor, Sonia.
Wonderful. So I wanted to do that to get an understanding of where we are as far as knowledge with what is a will. Like, that's how I started. What is a will? Well, it's a legal document that sets out the wishes of the testator being the person who created the will. In the will, you're going to have two important titles. Executor is the person who carries out your will and distributes the estate at the end of the day. And what is the estate? The estate is anything that is not assigned a beneficiary designation. So for instance, real estate, investments, personal items, furniture, vehicles, all of that become part of your estate, become the value of your estate that needs to be assessed when we go to probate. I'll discuss probate in a second. But anything that has a beneficiary designation, so life insurance, RSPs, you can designate a beneficiary there that doesn't get included in your will. What's the benefit of that is that you don't have to pay the administration tax on that. That goes directly to your beneficiaries that you designate, and it goes immediately. Like within a week or two after death, that can go immediately to your beneficiaries to help with anything that they need immediately. Probate, depending whether you live in Toronto or outlying areas, probate can take as long as a year. Like, it was awful during COVID. It's gotten a little bit better now, but yeah, probate can be a year. So if your family is waiting on the assets, that can put them in a bit of a financial struggle. So diversifying assets, not all, just strictly in real estate and pure investments, would be good advice to your clients as far as diversifying it into things with a beneficiary designation. Who are the beneficiaries? Beneficiaries are anyone that is named in the will to receive all of or a portion of the estate. That's the beneficiary. And then if there's minors included in the will as beneficiaries, we do provisions for guardianship. Who will take care of them until they are 18. And then we also make provision for distribution over age milestones. Some people want their children getting everything at 18. I don't. I wouldn't give my kids everything at 18 because I know they would just spend it on like musical instruments and like clothing. But I would, I have it distributed over age milestones, and whatever those are specific to the individual. I often get the question, do I need a will? And I always tell my clients, if you don't plan on dying, you don't need a will. So the answer is yes, we do need a will. Unless your estate is under $50,000, then you don't need one. You don't need to probate. Everything can be distributed. And that was something that just came into effect in 2020. But if you have real estate, like many of your clients do, a will is necessary. And that's something that, you know, they can contact me for and just say, okay, this is my situation. Do I need a will right now if the only asset I have is my home and it's joint with my spouse? Well, if that's the only asset, then probably not. But if they have other investments and whatnot, then yes, likely they would need to have a will. The will essentially makes it easier for family members to carry out their wishes. They apply to the court, they pay the probate tax or the administration tax, which is approximately 1% of the value of the 1.5% of the value of the estate. And then they give us a certificate, and then the executor or the estate trustee can do whatever the deceased person could do with their assets. That's what they can do with the assets. They can hold them, they can rent them out, they can remortgage them, and, you know, buy other property if they so intended to, always with the interest of the beneficiaries in mind. So if the executors are acting as both to carry out the disbursements and also as a trustee for minor children, they might want the estate to grow, they might have to make other investment strategies and all the like. So the question then becomes, who do I make my executor? And that's something we'll address in a minute. If you die intestate, that means if you die without a will, the issues are the court application gets a little bit more onerous. The court will ask you to put up a bond, which could be the full value of the estate. That could be prohibitive for most to be able to put up a large chunk of money. An administrator or a public trustee and guardian could get appointed if the next of kin isn't readily available, and you don't want the public trustee in your business at all. They just create another layer of red tape, and I just had to deal with the public trustee on an estate file, and they were really easy to work with because normally they're not. Yeah, they just kind of backed off and that was that, but normally they're not. They're in there, they're scrutinizing everything, they're registering liens against the property. So you really can't do anything with the estate without their approval. So it just becomes this extra burden on the family members who are already struggling to get this application in quickly and the will probated. You can apply to probate without a will. Again, it just gets a little bit more onerous, and we have to request things to be waived from the courts and whatnot.
Sonia, maybe I could just jump in. I can only imagine what it's like to deal with the public guardian and trustee, because we had the pleasure of dealing with TD Canada Trust last year, who were hired by an out-of-country executor, and they figured if they had somebody here to run the show, it would be that much easier. And it was just an absolute nightmare. It was awful. It was just a really, really awful process. I was very grateful that these clients hired us because they would have been in a much, much worse position. I kind of like guided them through how to deal with TD Canada Trust.
Yeah.
So I can only imagine if you're dealing with the province, what it would be like when at least if you're TD and you're hired, do you have some semblance of responsibility and care? But with the province, there would be none. It's just a transaction.
It's just a transaction and they're inundated. So it just adds more time to your process. And yeah, it's not fun. So I always say to my clients, get a will, because at the very, very least, even if your estate is nominal, at the very, very least, your loved ones that you leave behind can just go through the process in a streamlined fashion instead of a challenged and, you know, onerous fashion where you're having to, like, you know, carve through red tape and whatnot. Yeah. Yeah. So the other sort of little note I put on sort of the checklist of today is, who should I name as my executor? And you had mentioned an out of country executor. Well, if they're non-resident Canadian, if they're not residents of Canada, they have to put up the full value of the estate as a bond with the court. It gets paid back to you, but let's say the estate was $1 million. they have to put up the full bond of $1 million. We can request it to be waived, and we have done that on several occasions, but they're not, the courts are not easy to provide the waived bond. Why? Because they're afraid that once we give them the certificate, they'll just take the money and take off. And then there's no recourse for any of the beneficiaries. So they're just trying to protect the beneficiaries to make sure the will that gets distributed, and then they will get the bond released back to them.
Oh, interesting. We had a question in the chat, Sonia, from David. Sure. What is a transmission application, and why is it needed for the trustee to have to transfer the property when sold?
Okay, a transmission application just says that the executor who has the certificate of appointment has now taken over ownership of the property. So it's like an interim. It's like an interim transfer from the deceased to the executors. And then the other part of the question was?
Why is it needed for the trustee to have to transfer the property when sold?
Because it's a necessary step in the process to have the transmission first. Now they're officially the owners, and they can transfer to the buyers, to the next owners. Yeah. It's essentially validating the certificate of appointment of the estate trustee, confirming that all that has been done correctly, making sure that we swear to certain statements, like the deceased doesn't have any debts, et cetera, in order for the property to be transferred.
Great, thank you.
Yeah, you're welcome. So I was at the point of who should I name as my executor? So Canadian resident, and also anyone that you trust, and that depending on the complexity and the value of the estate, you might want to also consider someone who has a good understanding of finances, good understanding of accounting, and is good with money. Because at the end of the day, they may need to make investment choices for the beneficiaries. And you want someone who has at least is aware of the options for investment and or how to seek advice from proper advisors. A lot of the times, people don't have family members that they can appoint. So they will appoint their accountant or their lawyer or someone that has a duty, essentially, at the end of the day. Yeah. And then I often get asked, how do I leave my estate and personal items to beneficiaries? And I always smile because I had a client who left her 3 cats to somebody. And it was pretty funny. I'm like, how do you know they want them? But I'm like, so you can leave anything to anyone. And you can do it by a general disbursement. So my whole estate to my children. Or a specific gift like jewelry, you can assign to a specific person. You can assign to charities and in percentages or dollar value. So there's various ways of assigning and distributing the estate to your beneficiaries. Yeah. Are there any questions in the chat? I don't have the chat.
Robin's got a question.
Oh, yeah.
All right. I just wanted to, it's more of like a statement. We just managed my grandfather's estate, and he had donated a bunch of money to charity, and he did it as percentages, and it was a disaster. And it took over a year to get down to the exact amounts because of interest rate changes and then taxes and then tax returns. So the one thing we took away from that, and the one thing the lawyer said too, is when it comes to charities, don't do percentages, do a flat amount, because it's a disaster.
Yeah. Was it percentages, like was it just charities, or was it family and charities and doing the percentage?
I'm pretty sure it was just the charities got percentages.
Okay.
Yeah.
Okay.
Yeah.
Okay, because normally that's a little bit cleaner when you add on family distributions and percentages, and then charity distributions and percentages, it starts to get even more complicated. But thanks for that, Robin. I think we did have another.
Yeah, David asked if you do, so for example, to Robin's point, if you do a flat amount, what happens if there's not enough money? I think probably if you're going to be leaving an amount, you're probably going to know what you're going to have in your estate, I would imagine.
Yeah, or it just gets proportionately decreased per charity. Like if there's, you know, a few dollars missing, I think everyone just gets deducted those few dollars. But I heard you guys say that you work with downsizers, that you're a senior specialist, you want to know the process of estate sales. So it sounds to me like you want to assess the needs of your clients. So they're seniors, do they not have wills? Or have they not been updated to really account for the most current situation that they're in? And what have you seen with respect to the downsizers who are now, you know, ready to retire? What have you seen in these instances that have, you know, brought you here to want to ask me questions?
Go ahead,
So I think it's great to have the conversation about wills and estates when there's so many people, older people, that don't have a will, and they think that, hey, when I pass away, I'm going to leave it to my kids to sell or do whatever. But they don't realize that there's probate and the time involved, the money involved. And also, if their kids just take ownership of that, how does capital gains come into play? So I want to know better how I can advise them to speak to a professional.
And you know what, maybe before L'Oreal and we jump into you, I think we need to have that distinction between, so we have will and estate planning, and then we have an estate sale.
Right.
So I think we could probably have a whole class on just estate, selling an estate. I think we're focusing more on the planning, which is more of your questions as far as, you know, how to deal with the people who are still here, and, you know, how you can advise them and what you can suggest in preparation.
Yeah. In regards to advising, I think the important thing to let them know is you need a will. If that's the situation, Natalie, that you're facing, and I'm sure others are facing, you need a will to make it easy for your loved ones at the end of the day. It's not costly to get a will, and it's not time consuming either. We make the process really, really simple. We send out a questionnaire, fill up only the questions that pertain to you. Immediately we'll draft the will, send over a draft for review, and then finalize it. We try to get it done quickly because people, again, change their minds and put it on the back burner, which I find always scary. But the importance of the important information to pass on is secure a will. This way you have the peace of mind that your children now know exactly how to distribute your wishes. And at the end of the day, anything inherited through the estate is protected under the Family Law Act. You don't have to declare it as spousal, any distribution between spouses. So if there's a breakdown of a relationship between two, the children and their spouses, they don't have to share it with the spouse. It's an inheritance, so it protects it from that perspective, and also from a capital gains perspective. And check with your accountant. I am not an accounting specialist. However, I can generally say that it protects it from that as well. So it protects it from tax and capital gains. Depending on what you do with it afterwards, then it may incur capital gains, but in the transfer through the will, it's protected.
L'Oreal, you took your hand down. Was your question answered?
I think I forgot what the original question was. I think she put out a question and I was going to answer that, and now I forget what the original question is. But I think I was going to say, like, in some ways, if we're talking to, like, to Natalie's maybe point of how do we address it with people, sometimes if you can, and Robin gave a good example of, like, say, personalize it. So you're dealing with somebody older and say, you know, after the sale or the purchase, whatever the situation is, you might want to think every time we have a major thing in our lives, we should go back and see if we need to update our will or make sure we have a will. For example, like, I know that, you know, Robin can give the example of the percentages, and now I can too, as saying, well, I had a friend that you might want to think about that. I know that I personally am going through this right now with my mother-in-law, and thankfully she had a will. It was also like 30 years old. And in our situation, it was good. My husband is an only child, and so it was pretty clear. He's the executor and the beneficiary. But if the situation was different and had he not been around, her will stated that the executor and then the two beneficiaries were going to be like his first wife that nobody has seen or heard from in like 25 years, and a cousin that might have already predeceased her. So like the provisions, it can be out of date no matter what. So I think it's worth looking into, like, reminding your clients. And this was something I worked on for a while and it didn't work out because she's gone now. But just to say, maybe every 10 years, have a little look and see what life changes have happened, both for you and for the people that you're leaving things to, and having to be your executor.
Good advice. Thank you for
Yeah,
that.
absolutely. And, you know, having a will is the first step. I think it also has to be a comprehensive strategy. For instance, with people selling their, you know, larger homes, downsizing, having this extra income now, extra money, what do you do with it? You know, so it has to become part of a discussion with the will and the larger investment strategy and the, you know, retirement, or what are they wishing to accomplish? You know, travel the world yearly, or, you know, I don't know, but, you know, set their goals up so that they can also have an investment strategy component to their estate planning. And for larger estates, you know, there might want to be some discussion about, you know, creating a family trust or creating these other solutions to account for who ultimately will receive these funds, and in the most strategic, with the most strategic accounting perspective as well. So that it's a group of people that have to take part in the estate planning side of things. The will is very simple, starts the process, lays everything out. The estate planning is more involved depending on the value of the assets of our clients. Yeah. And the other thing that I wanted to mention is, as part of our wills, we always do powers of attorney. So what are powers of attorney? Powers of attorney are when you're still alive but incapable of making decisions over your property and your personal care. And those are very important. And those need to be trusted to, you know, someone who that you feel will make the right choices for you. And it can be different. They don't have to be the same for personal care and property. But those are very important choices as well for your care while you're unable to make decisions while you're still alive. And you know, another thing with aging parents and aging children, maybe, you know, when the parents pass on, the children are not capable any longer as well of being the executor or anything like that. Or maybe the children, you know, the older adult children are not capable of making these decisions because of various reasons. And so we have to account for that. And if you have a will, you can make sure that they're protected by putting the proper executors in place and making sure that there's a trust relationship with the adult children who perhaps need further assistance. And if they are getting any government assistance, we can also account for that in the will, so that doesn't eliminate their government supports that they have offered to them in some instances. Yeah. I see questions popping up.
I have a question, please. In today's world, some wealthy people keep their money and real estate assets in a holding company or a few holding company. So what's happened if the shareholder of holding company pass away because the company is a corporation and separate entity? Thank you so much.
Thanks, Ben. There's something called the excluded will. So it's a corporate will that essentially addresses any assets held in a corporation. Normally we say to have an excluded will, you probably want the assets to be fairly significant, you know, above 500,000, but that's not prohibitive. You can have an excluded properties will at any point in time and any value in the corporation. What it does is it actually removes the need for probate. So any assets held in a corporation can actually go straight to the beneficiaries. So if you have clients who are holding assets in a corporation, real estate, for instance, I would strongly advise to have the personal will as well as the excluded properties will or the corporate will layered together.
That's interesting. Thank you for that.
Yeah, welcome. The main thing is because you don't have to have it probated, you don't have to wait, you don't have to apply to the court. The assets go straight to your beneficiaries, or someone can step in and continue to run the operations of the business so that there's no delay in time.
Interesting. Lori Ellen?
I had a question with estate planning, and you have what do you call it? A real estate asset. Is it better, say, you have 2 children? Is it better to have them like named as sort of co-owners, like put onto title before you pass, or is it better to have them as a beneficiary and you know, not on title?
So it all depends on what the children want to do at that point in time, because if they're added on as an owner, then and there's any income derived from the property, they have to start paying taxes on that income. So say it's an investment property. There also will be a capital gain. Your capital gains time frame will start as soon as they're on title and they don't reside there. So
okay,
when
so
they
the parents still live there, yeah. Even if the parents still live there and it's not an income property, but now it's a capital gain starting from the date you're on title, not the day they pass.
Right, and depending on whether there's a mortgage or not on title, if there's a mortgage, the children would have to pay land transfer taxes when they come on and purchase part of the property. If there's no mortgage, we can just do it as a gift and it doesn't matter. But there's sort of financial sort of implications of doing that. So it depends on what their intentions are. Some children do get on title and it is because that was their strategy. But as far as, I'll repeat what I said earlier, is if you inherit through the estate, you don't pay anything. No land transfer.
1.5%, yeah.
Yeah, the 1.5 for the whole estate. Yeah, exactly.
Yeah, so that's
so you have to value. Yeah, and you'd have to almost assess what is most cost effective.
Yeah.
Yeah.
Good. Yeah. Thank you.
Yeah.
Great. Thank you.
Question? No? Okay. So just to touch on estate sale, because I think, Lan, you had mentioned that it's not part of this discussion. It's separate and apart from that. But estate sales, if I can impart any advice onto agents who are doing this, is to make your provisions in the agreement of purchase and sale very, very clear about when your client can exit the deal if you're the buyer and the seller has not provided probate by a certain time. Because what I see from my perspective is these open-ended, I will give you probate when I give you probate. And it's like, okay. And during COVID, we waited for like over a year. So if that's the situation, clients, the buyers may want to change their minds. So put a clear termination date as to when the buyers have the choice to exit the deal. If it's a probate application, and always inquire, when was the probate application filed? How long do you expect, in what jurisdiction, so Toronto or elsewhere? And then you can gauge roughly how long it will take for the application, like the certificate, to be issued. It's very, very important because you don't want to leave your clients in an open loop where they now have to just wait because they're committed to the agreement. Yeah. Yeah. Yeah.
It means that if I see in the listing saying there is a trustee or there is an executor, it means that the application is already filled and already appointed to.
Hopefully. So hopefully, if they're noting them as like the executor, then hopefully they've already filed their probate. Just ask for a copy. Ask for a copy of the certificate. And then this way, as soon as you get the certificate, you know that it's been finalized. If they say, oh, no, it's still in the process with the courts, then you'll want to ask those additional questions that I just posed to you.
Okay.
Yeah. And make sure you put a termination date so your clients can exit in the event that probate takes longer than 3 months, let's say.
Mm-hmm.
Yeah.
And you say usually, sometimes it takes a year.
It can, and it can take over a year sometimes, depending on the court, depending on how many times they want you to correct the minor detail that they think is incorrect, and it can come back to you several times as well, or just their processing time is really lagging. Yeah.
Thank you.
Yeah. But if you have any estate sale issues, feel free to give me a call anytime, and I can help however I can. Yeah. Sure. And that goes for anybody. If you have any questions, like what I normally do with my clients, if I'm not a specialist in the area, I always just connect them with someone who is. So I'll always just be like, okay, this is who I trust. I'm going to connect you both. And please, ask your questions there. Feel free to do that with your clients. If they have any wills and estates questions, just connect me via email. I'm quick to respond. Make sure Selena is copied because we'll be even quicker to respond. Selena's my clerk, and we'll make sure we're addressing their questions.
Thank you.
My pleasure.
Are we opening the floor to questions? I think we've been so efficient. Very, very efficient. That's amazing. So I actually will ask you about the corporate will.
Okay.
Yeah, because that's not something I don't know. Maybe since we've got a little bit of time, maybe did you touch on that? Because that would really be of interest to me. We have a couple of corporations. Well, now more because we've incorporated as realtors, but we do have a couple of corporations that hold our properties.
Yeah. So, and that's okay if it's multiple corporations because you can do that within the will. So, a corporate will essentially mimics your personal will, except that it removes all of the corporate assets. So your corporate assets, you still own them, like as an individual because you're a shareholder, for instance, right? So you still own them personally. So they will automatically get captured under your personal will, but your corporate will or your excluded properties will removes those corporate assets and now puts them into this corporate will setting. So when your corporate will is read, that's when your corporate assets will be distributed. And that's when you can say, the real estate in, Ontario Inc. can now become part of the estate value that's going to be distributed to my children. And then, so that happens immediately. And then when your personal will needs to go get probated, it's only your personal assets under your personal name. Mm-hmm. And that's it. Mm-hmm. So essentially it just carves those out and allows you to distribute them immediately to your beneficiaries. And it's literally, they're identical, except for a little bit of language that points out the corporate assets and will delineate them more specifically. And there's a need to update that. I try to use general language, like all assets under this corporation, all assets under that corporation. But if you dissolve a corporation, we'd have to update it. And so we'd have to add a code and whatnot. So I don't put the addresses. Some clients like the addresses. I always advise against it. But if we put just all of the assets under this corporation, then that gives you some flexibility to grow the assets under there. And yeah, but if you're adding corporations, or then we'd have to update the will regularly.
Right. Yeah.
Which is simple.
Wills go to probate?
Sorry.
Do corporate wills go through probate as well?
No. That's
the whole point.
Because that's what it sounded like. I'm like, oh, that was fast.
They don't go through the will. Yeah, that's why I said when they're read, you can distribute the assets.
Okay, that's different. I like that.
Yeah. Yeah, I know. I guess we'll be talking, Irene.
We will be talking.
Yeah.
That's great. Anybody else? Any burning questions?
I asked a question in the chat. I don't know, I missed the beginning. So did you talk about separate wills for real estate if they're exempt from probate?
Or first title?
First time in land titles exemption?
Okay, so you're talking about transferring a property if it's under the first title rule.
Yeah.
Okay.
Because that doesn't have to go to probate. So my lawyer had me put separate wills for every property.
Oh. Really? Well, I'd like to talk to them about that, because I don't know why that would be necessary. Because when you search the title will tell you if there was any transfers after land titles conversion.
Right.
And if there's no transfers after land titles conversion, then that is a first title stealing. Sorry. That is a, can you hear me?
We can hear you, but your video just clicked off.
I don't know why. Give me one quick second. There we go.
There we go.
All right. So we search the parcel register and we see the land titles conversion date. And if there's no transfers after that date, it's a first titles rule. So we can essentially transfer the real estate without having to probate it, and that gets carved out of the will.
Yeah, you don't have to pay probate on it.
You don't have to pay probate.
Yeah, that's why he said do it separate from your monies.
I'd have to think about that one, because I don't see why your will would be necessary.
I think if you had everything in one will, your monies and your property, and the property is exempt, you'd have to declare the value of the property when you do the probate. So
it no longer exists. It no longer exists. You don't have to declare the value any longer. It's transferred. It's done.
It's not part of your estate. Yeah.
If anything gets transferred out, you cannot value it any longer. It does no longer becomes part of the estate. But I'd love to speak with your lawyer to see what the intention behind it is. I'm sure it's a clever one. I don't see the I don't see how it can get pulled in after it's been transferred, because the value is no longer there.
No, but it's in the estate when the people die, right?
In the estate when the people die, but the executor can now distribute that or put it in their own names, and it's no longer part of the estate.
Yeah, he can't put it in his own name until he gets probate, because the trustee can't do anything. It gets appointed to be the trustee, and that's, you got to file probate and pay the tax first.
But they can transfer it to the.
No, they can't. They can't transfer it yet because they're not the trustee yet. They're not appointed. Right, you got to go to.
This might be a longer discussion.
Yeah.
You got to be appointed, right?
Yeah, let's talk about this another time. I'd love to get a call from you and know who your lawyer is to understand the strategy behind that, for sure.
So Sonia, you know what, I think David touched on something that I only learned about in 2017, and I know you did a bit of an explanation just now, but I think there's a lot of there's a lack of understanding about what first titles actually is. I had to have the lawyer for the estate executor explain it to me 5 years ago, and I'm 31 years in the business, and I didn't know what it was. I didn't know what first titles was. So could you just give like a little snippet of explanation about it?
Essentially, when land titles converted the properties, they essentially created this rule that says it. So you guys know how to, like a parcel registry. It'll, sorry, say it again.
It came from the land registry when they converted everything over.
Exactly. So the rule came out that after this certain date, and every date is different, but they're in and around the same times, but every date is different. After this certain date, if there was no transfers, then the exception was you can transfer this property to a verified buyer without having to go through probate. And effectively, you have to fill out, the lawyers have to fill out certain affidavits that accompany the transfer, and we have to make some statements. But effectively, you can transfer it without having to probate the will. And it removes the time frame that the transfer can happen, and it allows for the buyers to get the property in short order. That's effectively what it is. And it was something that was created to streamline the process so that properties could be transferred. Yeah.
That's great.
And a lot of agents don't know this. And so when you read the agreements of purchase and sale, and some lawyers don't know this. So when you read the agreements of purchase and sale, and you take a look at your, I guess your Jira warehouse transfer dates, if this is something you know, that's going to be part of an estate, take a look at that land titles conversion date and put it in there. This is a first dealings transaction, so that the lawyers know on both sides that you've seen this. This is, you know, this is potentially a first dealings transaction, because a lot of lawyers don't know it, and they go through the probate process. And I look at the parcel after the fact. I'm like, why the heck did you file for probate? We could have just done this really, really easily, right? Yeah. So
how do you figure out that date again? Sorry, I'm only learning about this the first time too, and now I'm still a little confused.
I'm gonna go grab a parcel register.
Listen, Lori Ellen, you know, it was 25 years before I found out about one of these.
So what is she saying? Is she saying that like it's the very first sale of the house since the original buyer? And so that was in the old land registry system.
Yeah.
What year did they transfer the files?
Most of them were transferred in the early 90s, but there's some that were in there way before that.
I'm thinking maybe my mother-in-law's condo. Could it be in condos too?
Well, when was it built?
All property.
It was 1986, I think.
No, it needed to be older than that.
No, it might have been she's owned it since then?
Yeah, she was the original buyer from the
builder. It's probably exempt from probate. How much is the property worth?
Ignore the names.
5-ish, 550.
Okay, guys, let's see what Sonia's got for us.
So we have what you're going to see is in the estate qualifier section, you're going to see what it says there, like fee simple, land titles absolute. It has to say something to that effect: land titles absolute plus, land titles absolute, land titles conversion. And then what you're going to see right across from it is the PIN creation date. And the PIN creation date is the date that matters. So the 2015 date that matters. If this person had died and the last transfer was prior to 2015, which it isn't in this case, and the last transfer was prior to 2015, you can rely on the first dealings rule. So it's first dealings after the PIN creation date, but it also has to say land titles absolute or land titles qualified. If you encounter something like that, call me. That's all. That's easy.
That's the simpler answer. Yes.
Yeah.
And if lawyers don't know about it, Lori Ellen, you don't have to feel too bad for not knowing it with, you know, a couple of years of real estate under your belt.
Absolutely. And I, you know, my mentor is a senior lawyer who's very well known in the industry. And, you know, most of the stuff I know is because we talk. all the time. And I ask questions and we figure things out, and you come up with situations that force you to learn this stuff as well. So, you know, always ask. And if something is peculiar, just there's always an opportunity to learn from that, and just ask. If I don't know, I'll find out. You know, if you come up with a question for me, I will definitely find it. I'm like, that's unusual. That's why hearing what David had to say, I'm like, I'd like to know about that, you know, because there's always different ways of doing things, and we learn every day. Yeah.
Well, Sonia, this has been amazing. Thank you so much.
My pleasure.
You're a wealth of knowledge. I could probably listen to you for another 2 hours, but maybe somebody else has the time to do that. So we'll make sure to distribute your contact information through the Market Center so agents can get a hold of you. And
great. And if anyone wants to email me their contact information as well, I'd love to, you know, stay in touch in regards to what you're doing. And if you do have any questions, or, you know, just make it easier for your clients to get in touch with me, you know, just send me your emails. I would love to have them, and just stay in touch. Yeah.
I'm just putting all of the information into the chat.
Yeah, and if there's anything we can do to help you with real estate as well, that's something we do a lot of, and can help support you and your clients with any questions. Yeah.
Awesome.
Yeah.
Thank you for being here, Sonia. Thank you. Round of applause.
Thank you. Thank you.
All right.
I look forward to meeting you all in person. This is so weird doing it this way, right? These types of, yeah. I like to feel the energy of the room.
All right. Thanks, everybody. Have a great afternoon.
All right. Take care.
Bye, Sonia.
Thanks
very
much.